Did you know that the Federal Maritime Commission released an interpretive rule on detention and demurrage in 2020? And it was published in May of 2020, right after the pandemic began, but before everything got really crazy with the supply chain. Hi, welcome to By Land and By Sea, an attorney breaking down the week in supply chain, presented by the Maritime Professor, me. I'm Lauren Beagen, founder of the Maritime Professor and Squall Strategies, and I'm your favorite maritime attorney. Join me every week as we walk through both ocean transport and surface transport topics in the wild world of supply chain. As always, the guidance here is general and for educational purposes only. It should not be construed to be legal advice, and there is no attorney-client privilege created in this video. If you need an attorney, contact an attorney. So before we get into the discussion of the day, let's go through my top 3 stories of the week. So number 1, the ILA, the International Longshoremen's Association, essentially the East Coast Ports Labor Association, is alleging price fixing at the ports of Savannah and Charleston, arguing that they created effectively, and I quote, a single terminal operator that controls rates, charges, and bargaining opportunities in the southeastern region's largest 2 ports, Charleston and Savannah. Now, this is currently being reviewed with mediation dispute resolution at the Federal Maritime Commission, but the complaint also has been submitted to the U.S. Department of Justice and Federal Trade Commission for antitrust violations. So 2 things to note here. 1, by sending it to mediation, it's actually a common practice at the FMC, certainly in recent days. These days at the FMC, as I understand it, initially, I was kind of reading into that, but there's nothing really to read into. In the Consumer Affairs and Dispute Resolution section of the FMC, it's one of the offices of the FMC, they have certified mediators. And so as I understand it, mediation is kind of a common practice on first step for complaints. So 2, I also wanted to note, and maybe just a coincidence, but maybe this is a follow-on, or maybe this is a continuation of an otherwise disputed area of these 2 down in the Georgia, South Carolina area, Charleston, Savannah. But in 2019, there was a proposed agreement filed with the FMC. So in 2019, from Ports America, Florida, SSA Atlantic, and Ceres Marine Terminals. And they would have called it the Georgia, South Carolina Marine Terminal Operator Cooperative Working Agreement. Now, it was withdrawn, and there wasn't much information released after that withdrawal. So like I said, I don't know if this new allegation is in some way related to the former agreement filing that was then withdrawn. Just interested to note that was brought up after I had posted this article on LinkedIn, that there was also this proposed agreement that was withdrawn. Maybe this is a follow-on. Maybe there was contention previously, and when it was withdrawn, maybe this contention continued. I don't know. I'm going to keep watching this. Maybe they're not related at all, but I'm going to keep watching this. I think this is interesting. So story number 2. The FMC's ANPRM, the Advanced Notice of Proposed Rulemaking on Detention and Demurrage Billing Practices, is now closed. It looks like the FMC is actually still accepting comments, though. And really, why wouldn't they? They have 79 comments filed, and at least 4 of them have come in after the April 16th deadline. So if you have not filed your comments yet, you definitely want to. You might still have a chance. It looks like the most recent filing was maybe a few days ago. Look, I've said it before, I'll say it again. These comments are chock full of really interesting perspectives of the industry and really provide nuanced explanations of the problems that each section of the industry is seeing. I highly encourage you to take a look at these. I'm going to link the docket 22-04, the link, so that you can go check out the comments yourself in the show notes here. This is really, such a wealth of information. I really encourage you, even if you just cruise through them, you click on it, you cruise through the comments, you're going to learn something, and I really encourage you to go check it out. So story number 3, the Maritime Professor is live. That's me. But really, I said this last week, it's like really live. The website is up now. So go check out www.themaritimeprofessor.com and make sure to sign up for that email list. The first drop of courses is coming very soon. But being on the email list is going to give you exclusive access to a promo discount code for the course. So sign up. Not only will you be alerted to when the first course drops, but you'll also be alerted to, you'll be given this promotional discount code. So the Maritime Professor, we talk ship. So let's get into the meat and potatoes of the day. So the Federal Maritime Commission has been really working toward clarifying the detention and demurrage world, as we know. And they really have been working on this for a while. They've actually done some work on this previously, and I'm often asked, why is all of this just happening now? Well, the FMC has been dutifully working on correcting some of the bad behaviors of detention and demurrage for a while. So if we go back as far as under former chairman Mario Cordero, in 2015, a congestion report was released. Sal Mercogliano actually covers it in What the Ship and what's going on with shipping. So I suggest that you head over to his YouTube page to check out his really deeper dive into the congestion report. And, shortly after 2015, that's when Commissioner Rebecca Dye stood up the supply chain innovation teams, the SKY teams. And then that led into a few different fact findings. But through all of this work, the FMC has also actually released an interpretive rule, which was published as part of their regs. So quick little law lesson here. You may hear statutes, you may hear regs. They are different. So Congress makes the statutes. So that's the Shipping Act in this case. And the federal agency, the Federal Maritime Commission here, creates the regulations. And those are really interpretations of those statutes that Congress makes. So statutes are made by Congress. They give the authority to the federal agency, which is the FMC, and the FMC then turns that authority into kind of rules that society, that the industry can then abide by. So there it is. Now you can go past law school. You can be a lawyer yourself. Again, this is not legal advice. This is just general educational. So there it is. But seriously, so the FMC used that authority to create an interpretive rule and put it in their regs, in their regulations. So under 46 CFR, so CFR is the Code of Federal Regulations, 46 CFR section 545.5, you will see the title is Interpretation of Shipping Act of 1984, Unjust and Unreasonable Practices with Respect to Detention and Demurrage. Did you know that was in there? Look, I have to be honest here. I knew there was an interpretive rule, but honestly, I didn't actually realize it was codified in the CFR, in the Code of Federal Regulations. So let's dive into it. What does it say? So there's 6 sections with some subsections within, and they are: 1, purpose. They describe the rule to provide the guidance. 2, the applicability and scope. So this is practices and regulations relating to detention and demurrage. They say, and I quote, "The purposes of this rule, the terms demurrage and detention encompass any charges, including per diem, assessed by ocean common carriers, marine terminal operators, or ocean transportation intermediaries, regulated entities, related to the use of marine terminal space, for example, land, or shipping containers, not including freight charges." One of the other sections is incentive principle, and underneath there we have cargo availability, we have empty container return, we have notice of cargo availability, and we have government inspections. Another section is demurrage and detention policies. There's also transparent terminology. And the last section is non-preclusion, where they say that they're not precluded from considering factors, arguments, and evidence not outlined in this rule. It's a smart little carve out. So non-preclusion, basically they're saying we're going to provide some guidance here, but we're not going to lock ourselves in. This is just guidance. This is supposed to be helpful. But if there are other arguments or factors or evidence that gets brought up, we're going to go ahead and consider that as well, or we're not going to preclude ourselves from being allowed to consider that. So now interpretive rules that are actually codified are pretty rare, as I understand it, but this was an area that the FMC saw greater confusion and contention around. So they wanted to get out ahead of it while they continued their own rulemaking quests. We've actually seen one of those recent rulemakings, the advance notice of proposed rulemaking on billing practices. We've talked about it a lot before. I suspect that they will continue to find areas that may need further cleanup in the detention and demurrage area. But let's continue on with today's topic, this interpretive rule. So the incentive principle. So the rule says, and I quote, "In assessing the reasonableness of detention and demurrage practices and regulations, the Commission will consider the extent to which D&D are serving their intended primary purposes as financial incentives to promote freight fluidity." So, You might ask, did the FMC have any clarifying statements in the reasoning behind the sections of the rule? Look, I'm glad you asked. Yes, they did. So when they published the final rule in the Federal Register, essentially the Federal Register is essentially the public notice like newspaper. I like to think of it as like a classified section of a newspaper, but like for the entire government. And you may not consistently read it. I don't know many people who actually consistently read it, but it's where all the required public notices go. So the Federal Register. So the FMC outlined what they considered to be detention and demurrage. They published the whole final rule in the Federal Register, and in publishing the final rule, they had quite a bit of explanation over why they chose the certain words that they chose, why they amended this final rule, much like we're going to see the process play out in the advance notice of proposed rulemaking, the billing practices of D&D. This was the interpretive rule, and they really wanted to explain some of the comments that they took into consideration, some of the comments that they disagreed with. So that's what this Federal Register publication, in more than just publishing the final rule, that's the explanation that was associated with it. So the FMC outlined what they considered to be detention and demurrage specifically for its purpose. And they said that historically, the commission recognized demurrage as having like penal elements designed to encourage the prompt movement of cargo off their pier. Like the charge increases in an attempt to penalize you for the cargo just sitting there. And that the charge has included compensation for associated services, such as, and they list, the use of the pier facilities, watchmen, fire protection, etc., on the cargo not picked up during free time. So the distinction here is detention and demurrage should be used for two demurrage, at least specifically here, should be used in two different capacities as they understand it. There's penalization for your cargo just sitting there, but then there's also a compensation for the services, for you watching over these goods, for the space that they're taking up. So the commission says it is important to specify, however, what this compensatory aspect of demurrage traditionally meant. So to the extent demurrage has a compensatory aspect, it was to reimburse ocean carriers for costs incurred after free time expired. So costs in this context, meaning additional costs associated with cargo remaining on a pier after free time. So the commission continues to say, in other words, demurrage and detention are not the mechanism by which ocean carriers recover all costs related to their equipment, and the commission cannot assume that these charges are the primary method by which ocean carriers recover their capital investment and container costs, as some commenters suggest. So I want to stop there. So they're saying that compensation does not include all costs related to the equipment. So some commenters have asserted that detention and demurrage should be used as well for lost business opportunities. The FMC is kind of giving a nod here to say that might be going too far. And that's kind of what they're saying, as some commenters suggest in the reading between the lines. So, I've said it before, detention and demurrage is not supposed to be a profit line. It's supposed to cover your costs and provide an incentive to move the goods. This is basically supported here by what the commission is actually saying. The commission continues to say, continues on to say, that the FMC cannot assume that demurrage and detention have compensatory aspects in every case. So it's not always going to require compensation. And certainly, as we've moved away from some of the different areas, those were kind of historical areas, use of the pier facilities, watchmen, fire protection, some other traditionally, now we have secure facilities. So maybe some of those compensatory reasons have dropped away a little bit. That's what they're kind of saying. They're saying that in not every case will there be compensation that is required. So as noted above, though, the rule does not preclude ocean carriers and marine terminal operators from arguing and producing evidence regarding compensation aspects of demurrage and detention. So they're saying you can still say that you have some sort of compensation that is required. If you have labor working to watch it, if you have policemen that do watch the area. The commission continued to clarify that they're going to continue to see detention and demurrage as primary as for incentivization of movement. but that they would also consider other purposes of D&D, such as we're talking about here, the compensation for the time on the yard. This was done by actually adding the new non-preclusion section that we mentioned at the beginning. So previously, before publishing this final rule, they did not have this non-preclusion section, but they wanted to afford for other opportunities of being able to consider arguments as they arose. They didn't want this to be the only guidance. They wanted to be able to take it very case by case. And so that's why they created this non-preclusionary section of the regulation. So under the incentive principle in the rule, the Commission also outlines particular applications of the incentive principle and includes cargo availability, empty container return, notice of cargo availability, and government inspections. So I'm not going to go into each one specifically, but let's talk about a few different main theme issues here. So first up, free time. So the FMC discusses this. The Commission says, and I quote, "First, as part of its transportation obligation, an ocean carrier must allow a shipper a reasonable opportunity to retrieve its cargo." In other words, free time. So free time is free because during this period, an ocean carrier cannot assess any demurrage. So nor can marine terminal costs be shifted to a shipper during free time, even in the event of a strike. So I point that out, even in the event of a strike, because I think that we're going to talk about that in a minute, but that is pretty interesting that in 2020 they were talking about that, and it will be relevant again shortly. So second, during free time, ocean carriers remain subject to 46 U.S.C. section 41102C. So this is the general general prohibitions of the shipping acts. This is the statute. This is the reasonableness standard. So I'm going to say that again. During free time, ocean common carriers remain subject to this statute section, reasonableness is standard. So it's basically saying practices must be tailored to meet their purposes. So the statute actually says, let's just go to the language. A common carrier practices in handling property. A common carrier, marine terminal operator, or ocean transportation intermediary may not fail to establish, observe, and enforce just and reasonable regulations and practices relating to or connected with receiving, handling, storage, or delivering property. So, going back to the beginning, this is the language of the statute created by Congress. Remember, the statute is created by Congress and the regs are created by the Federal Maritime Commission. So this is the actual language from Congress talking about having just and reasonable regulations. And so that's where they keep coming back to this reasonableness standard. And the practices need to be tailored to meet their purposes. So let's get back to the free time. And I understand that this is a little bit more of a dense topic today that we're covering, but I thought that it was important to dive into the interpretive rule here, just so that you are aware, one, that it exists, and two, so that you know that there's more to it here. So there's gotten a lot of attention on the detention and demurrage advance notice proposed rulemaking, but there's more that happened before this moment. And that's why I wanted to highlight this. So let's get back to the free time. So once free time expires, the first of these legal principles, allowing reasonable time to retrieve the cargo, drops away because the transportation obligation of the carrier has ended. So once the free time expires, you're no longer required this reasonable time to retrieve the cargo. And at that point, the FMC says ocean carriers can and should charge demurrage. So they're saying there should be a free time period, but the free time shouldn't be the only thing. And they understand that there are reasons why demurrage should be charged. They continue and say demurrage is a valuable charge when it incentivizes prompt cargo movement. The FMC notes that the tailored reasonableness requirement of the statute still, which the FMC says is financial incentives for cargo and equipment fluidity. If demurrage cannot act as an incentive for cargo and equipment fluidity because, for instance, an MTO is closed for several days due to a storm, charging demurrage in such a situation, even if a container is already in demurrage, raises questions as to whether such demurrage practices are still tailored to their intended purpose. So listen to what the FMC is saying here. They're saying that when you're in demurrage, they support demurrage. They think that it's a valuable charge when it does incentivize prompt cargo movement. But sometimes if there is a storm, that was their example, if there's a storm at the port or the marine terminal, charging demurrage at that moment, even if the container is already in demurrage, they're just saying it raises questions as to whether such demurrage practices are tailored to their intended purpose. So they're not going so far as to say you can't, but they're saying that that is something that they're seeing go in the wrong direction as reasonableness and a tailoring to the spurring and the incentivization for the movement of goods. But let's go back. You could also say that you needed compensation for what you needed to do for those containers that day. This is all starting to build on everything is going to be very fact intensive. As I said a few times before, I'm going to continue to say it as we dive into all of this. This is not legal advice. This is just an educational thing. I wanted to really walk through here. And so they're saying that this is very fact intensive. So what about when the beneficial cargo owner or shipper cannot pick up the goods? So we've talked about that before. What about the impossibility of a pickup? So the commission discusses that too. So when property lies at rest on a pier after free time has expired and consignees, through reasons beyond their control, are unable to remove it, the penal element of demurrage charges assessed against the property has no effect in accelerating clearance of the pier. They're saying basically, so if the cargo sits at the pier, free time is expired, and through reasons beyond their control, they can't come pick it up, the penalty that demurrage is using to accelerate the clearance of the pier isn't really there anymore. So the FMC continues, to the extent that such charges are penal, so a penalty, in other words, in excess of a compensatory level, so they're beyond just compensation for the burden of you holding these goods, the FMC says they're a useless and consequently unjust burden upon the consignees and a source of unearned revenue to carriers. So that's interesting. I've said this before, it shouldn't be a profit line, and the FMC is essentially saying that too here. They're not taking a hard line here, but they are saying to the extent that these charges are supposed to be penalties, so in excess of compensation for the burden, they're saying that these charges, these demurrage charges, are useless and unjust. They shouldn't be this extra burden. So the whole thing that we're talking about here is after free time, through reasons beyond their control, the cargo owner can't come pick it up. I mean, this is pretty interesting that the FMC was diving down into these examples, not drawing hard lines, but just trying to provide examples or a little bit of a nuance of where their head's at, what they're thinking. They don't want useless and unjust burdens upon consignees. They can't come pick it up. Quit charging them because they can't come pick it up and it's outside their control that they can't come pick it up. And they're saying that this is unearned revenue because you're not, the effect of you trying to get that cargo to move, the effect isn't there anymore. So they're saying that the incentive purpose is gone and now the charges are just an unjust burden and useless. Commission continues here. The commission therefore does not agree with some commenters' arguments that it is always a reasonable practice to charge detention and demurrage after free time, regardless of cargo availability or the ability to return equipment. The rule and the principles therein apply to demurrage and detention practices, regardless of whether containers at issue are in demurrage or in detention. That is, in assessing the reasonableness of demurrage and detention practices, this is important, the commission will consider the extent to which demurrage and detention are serving their intended primary purposes as financial incentives to promote freight fluidity, including how demurrage and detention are applied after free time has expired. So I'm going to say that again. The commission will consider the extent to which D&D are serving their intended primary purpose as financial incentives to promote freight fluidity. They're saying, look, I don't care what you think D&D should, I don't care that you think D&D should always be charged. Sometimes it shouldn't, and we're going to take that into consideration. So they're not, I keep saying this, they're not drawing hard lines necessarily, but they are giving some pretty solid explanations and pretty solid rationale for why they might disagree with some of the practices that are out there. And still saying that this is all fact specific and they're going to be considering all factors when a case is brought, but they want they wanted to really show where they're moving in their detention and demurrage assessment. So, one area I wanted to draw your attention to in here is where the commission discusses the comments regarding a labor strike and who bears the burden. So to distill it down very simply, essentially the commission discussed the difference between incentive demurrage and compensation demurrage. We've kind of talked about that a few different ways. So incentive demurrage is the charge is used as an incentive to spur the action, to get your stuff off the yard. But compensation demurrage is for the fair compensation for sheltering and protecting the cargo. The commission discussed that this is an appropriate charge for the demurrage. So look, ultimately, the FMC is saying that they will be considering the totality of the circumstances with this guidance in mind. And I wanted to bring your attention to labor strike. I almost don't even want to say it out loud, but we're about to have a very interesting time happening on the West Coast. Hopefully, it's no big deal. The labor negotiation is supposed to kick off middle of May. Hopefully, everything's fine. So the labor agreement between the ILWU and the carriers and the terminals is about to happen. The contract expires June 30th. So July 1st will be no contract. I don't know what's going to be happening here. Everybody so far seems to say everybody wants to find an agreement. They don't want any interruption. Industry itself has been starting to maybe hedge their bets here and move cargo a little bit, diversify away from that West Coast area. But who knows? Maybe everything will be fine. I just wanted to point this section out because they do start to talk about a labor strike and who bears the burden. I suggest you go check this section out. It's pretty interesting. Like I said, not hard line. This is not specific to any factors. I can't say it enough today. This is for educational purposes that we're discussing all of this. None of this is attorney-client privilege between me and whoever might be watching this. However, these are some interesting factors to consider, and I wanted to bring that up as we talk about the interpretive rule here. Like I said, ultimately, the FMC says that they're going to be considering the totality of the circumstances with this guidance in mind. So what about free time and the reasonableness of free time and available cargo? Look, the FMC covers this too. They say, simply put slightly differently, if a free time practice is not tailored so as to provide a shipper a reasonable opportunity to retrieve its cargo, it is not likely to be reasonable. But then they start to drill down on the different cases. Requests for free time to not start until the cargo is available, or when there is an appointment within free time, oftentimes they can't get the appointment, or when free time should stop when the container is non-accessible due to situations beyond the control of the shipper or trucker. And then they drill down further into terminal hours of operations, more discussion on appointment systems. And look, what about the chassis? So the commission addresses these by saying it makes sense that if free time represents a reasonable opportunity for a shipper to retrieve a cargo, it should be tied to cargo availability, and the commission recognizes the merits of that approach. But the commission will not, in this general interpretive rule, make a finding that failure to start free time upon availability is necessarily unreasonable. Let me say that again. The FMC is saying right here that they understand that if the container is not available, why are we being given free time? Because we can't even get it anyways. We don't even know if it's truly available to go pick up. The FMC is saying, look, we get that. We understand. Availability should mean availability, and that free time should be part of the availability time. But the operational environments and commercial conditions at terminals across the country vary significantly, and in some situations, there might not be much difference between tying free time to vessel discharge and tying it to availability. So they're saying in this general interpretive rule, they don't want to draw a hard line there. You're seeing a pattern. In this general interpretive rule, they wanted to provide some general thoughts, but they didn't want to create these hard lines. But there's a lot of value to understanding the general thoughts that the FMC is providing here. So they continue, for similar reasons, while the commission will consider in the reasonableness analysis how demurrage and detention practices address interruptions in availability during free time, requiring specific stop-the-clock procedures is beyond the scope of this rulemaking. The commission is sympathetic to shippers, intermediary, and trucker arguments that bright line rules will be more beneficial to them and would be clearer than the commission's factor-based approach, but imposing bright line rules could inhibit the development of better solutions. So I can respect what they're saying here, that maybe I almost see it down the road. They might start to look at, maybe this will turn into a rulemaking, trying to identify what availability means. We'll see. So they also say, as for defining container availability, the Commission declines to do so here, as it can vary by port or marine terminal. Suffice it to say, availability at a minimum includes such things as the physical availability of a container, whether it's discharged from the vessel, assigned a location, and in an open area where applicable. Depending on the facts of the case, the Commission may consider such things as appointment systems and appointment availability and trucker access to the terminal. In other words, they're going to be considering congestion as well. That's their concession. They're saying they're not taking a hard line here, but depending on the facts of the case, the Commission may consider these things. They understand that these are sometimes impossibilities. There's certainly headaches. There's something that they're seeing a lot of, and through the comment period of the 2019-2020 rulemaking here, this interpretive rule, they saw that as a problem. So they also address the chassis situation and basically say that's much more complicated. Essentially, the FMC said that they may, in an appropriate case, consider chassis availability in the analysis, but they say in doing so, the Commission would be especially careful to analyze how the chassis supply model at issue relates to the primary incentive purpose of D&D. So chassis, we've talked about this before, this is going to be a very, very basic thing. The container itself has no wheels. And so the container, in order to come off the yard and roll down the street, needs a chassis. That's where the wheels are. And so who owns the chassis? How many chassis are available? There's a thing called chassis pools. These are all part of that, what the Commission is alluding to here, saying that the chassis situation is very complicated. Maybe there's going to be a chassis rulemaking at some point. I think that they wanted to, there was a balance between really diving in deep and being a little bit more guardrail-y. And I think that they took the first initial moment here to be a little bit more kind of overall skeletal structure about it, to provide a little guidance on where their head's at. And then, as we're seeing now, billing instructions, billing guidance is their first rulemaking after this. I think that makes a lot of sense, because that's a little bit more general. They want to create consistency in the administration of D&D. So what about government holds? So the Commission addresses this also in saying that it will consider the reasonableness of government holds, much the same that it's going to consider any other circumstances preventing shippers from retrieving cargo. Essentially, the FMC said that the complexities of government inspections and the type of inspections make it difficult for the FMC to adopt a single approach here. Rather, they may consider the incentive principle in the government inspection context as it would any other context. I keep saying it, but the FMC keeps saying that they are going to be determining their view and review of any of these cases by a very fact-specific, very case-by-case basis. So this is only a little bit of the interpretive rule. There's quite a bit of explanation provided by the Commission on why they chose the language they did for this interpretive rule. And I really just wanted to draw your attention to a few areas today. And like I said, just let you know that this was out there. I want to provide some of these tools so that you can go look it up yourself. Once you start applying this rule to your specific case is when you start to get into the legal application. But most people can go and read through the comments, read through the interpretive rule and some of the commentary that the FMC provides, because it really is written so that everybody can understand it. So there's actually been a little critique of this interpretive rule, so saying that it doesn't say much or that it maybe is too soft. Look, the FMC is acknowledging that there are so many factors involved in determining the reasonableness of detention and demurrage, and they wanted to provide some initial clarity, but they certainly cannot create hard lines at this time through this rulemaking alone. They wanted to take the first step, and they didn't want to talk themselves out of taking that first step because they weren't going far enough. I think this first step has a lot of value to it, to the industry as a whole. So as more cases come in, more clarity is going to be provided, because as the cases present their specific facts, the FMC will be able to apply some of these principles and clarify the outer edges of the detention and demurrage and apply it and how reasonableness factors into it all. So questions about any of this, feel free to contact me if you have any legal questions in my legal capacity at Squall Strategies. But I want to say it, this is the Maritime Professor presenting by land and by sea. This guidance here is general and for educational purposes. It should not be construed to be legal advice directly related to your matter. If you need an attorney, contact an attorney. So if you like these videos, let me know. Comment, like, and share. If you missed any previous videos, they live on my YouTube page, By Land and by Sea, presented by the Maritime Professor. And while you're at it, check out our website, themaritimeprofessor.com. So until next week, this is Lauren Beagen, the Maritime Professor, and you've just listened to By Land and by Sea. See you next time.